Today we shall be talking about the difference between the transfer of a share and the transmission of a share. Let us take an example. Say this is Mr. P, right? He had some shares with him. Now he wanted to sell these shares. He sold off these shares to a new person who is called Mr. G. In return, he took cash from him and the deal happened for 20,000 rupees. Very good. Mr. G paid the cash and both the parties, Mr. P and Mr. G, they both were very happy. They were very glad. So it's a very simple example. People keep on buying and selling land, machinery, building, whatever. They find a person who suits their deal and they are ready to sell it off. So similarly, the shares were transferred from P to Mr. G for 20,000 rupees. In this example, this is Uncle Z. He is not keeping in his good health, but he had some shares with him and due to old age and XYZ reasons, he passed away. Now, before passing away, he made a will. And in that will, he mentioned that all his shares must be given to his neighbor, Mr. Y, because in his last days, it was Mr. Y who really took good care of Mr. Z. So what happened now? That the shares were given to Mr. Y. Mr. Z, so he passed out, right? There was no cash given by Mr. Y to Mr. Z. This will, it mentioned that the shares will be given to Y, but there was no consideration which this Y paid to Mr. Z. But he got all his shares because the will mentioned like this. So what is this? This is an example of transmission of shares, where the shares are being passed on from one person to the other, but there is no consideration. And there was a written will in which all this was clearly mentioned. So coming to the transfer of shares, the theory part, it is a voluntary act of a member. Voluntary means it's upon your own will. Supposingly I am having some shares and I want to sell them. So I voluntarily selling these shares. Okay. So like I sell other, like I have a car, I want to sell it. So that's my voluntary act of selling something. So similarly, transfer of shares is a voluntary act of a shareholder and this takes place by a way of contract. Intentional transfer of title of shares, like I, in my good health and in my good sense, I'm ready to sell off my shares. I'm going to transfer the title deed of my shares to XYZ person, and this deal takes place between the transferor and the transferee. We all know that the shares of a public company, they are freely transferable. There is no ban, there is no restriction on the mobility of shares. Supposingly I had some shares, I sold off it to you. You again want to sell them to another person, you can. And this can be passed on as many number of times as the owner wants. So they are freely transferable. This is transfer of shares. And in this, the transfer deed is executed for this transfer. It's a very simple thing. I want to sell this thing. You want to buy this thing. Okay, let's come forward. This is called the transfer of shares. But in the transmission of shares, the story is a little different. Transmission happens due to the operation of law. Law comes in between. The owner of the shares, either he passes away unfortunately, or he becomes insolvent, or he becomes lunatic. He's not in his senses anymore. So out of these three things, something happens and the law comes in between, and therefore the title of shares are transferred to somebody else other than the owner. Such a procedure is called transmission of shares. The shares, they are transferred to the legal representative of the deceased or of the person who's gone insolvent, etc. So they are given to the legal representative. Therefore, there is no need to make a document of transfer because transfer is not happening. It is a transmission. And this transfer of shares, the passing on of the shares to the new person happens by the operation of law. When a person dies and he leaves a will for the inheritance of his property, the property can be named in the name of the daughter, son, nephew, neighbor, or any relative, or a trust, or whatever. So that will is made that who is going to inherit my property. The person mentioned in the will, he will be entitled to get the shares, and these shares will be transferred in his name. In case that the dying person, he did not leave a will, many a times the person passes away and there is no will made for the same, then the claimant, so then somebody will come to claim that property. No, that okay, look, I am his nephew, or I am his son, or whatever, I am his neighbor, I am the claimant to that property, I am a claimant to those shares. So that claimant, he will have to produce the succession certificate in the court, and then he will be transmitted those shares. And if the person goes lunatic, then who is going to get it? The person who is the guardian of the lunatic, because until he is alive, there will be somebody to take care of that lunatic person, and the guardian, he will be getting the shares. And if a person goes insolvent, the shares are transferred to the official receiver appointed by the court. In that case, in the insolvency, the court will be appointing an official receiver, and then he will be entitled to those shares. Now, a legal representative. So, whosoever he is, right? The son, daughter, XYZ, whatever. Now, the legal representative, he can approach the company and get his name entered in the registrar of members, because now he will be the new member of the company. Whatever privileges the old person was entitled to, the new person will be getting the same privileges and the same benefits to which the deceased or the insolvent person was entitled to. Now, the legal representative, he can further transfer the shares to anybody else following the procedure laid down for such transfer. So, if you have got those shares by the procedure of transmission of shares, still you have the full right to transfer them further. Right? Supposingly, if I leave a will for you, and then you can get those shares and transfer it further as many times you want. So it is not a taboo that because the shares were given to you by the inheritance property, you cannot further transfer. Very well. Jitni baar marji you can transfer them. Take the cash, transfer them further. Now we come to the tabulated form of the difference between the transfer of share and the transmission of the share. And the first point is the meaning. Transfer of shares means the transfer of the title of the shares, which happens voluntarily by the wish of both the parties, and they, in their senses and willingly, they transfer, they sell off the shares to the other person, and they are happy to do so. In the transmission, the transfer of title is entitled to the new person by the operation of law, just as I explained you in the previous slide. Second point comes that affected by the transfer of shares is affected by the deliberate act of the parties. The buyer is happy to buy and the seller is even more happier to sell. They come out to a common price, and this is how the deal is executed. But in case of transmission, it is affected by death, insolvency, inheritance, or the person goes lunatic. So the case is different in both these things. Next is the transfer is initiated by the transferor and the transferee, because he wants to buy them and the other person wants to sell them. So this is how the deal is initiated. But in the case of transmission of shares, the deal is initiated by the legal hire or the receiver of the shares by the operation of law. Next point is consideration. Supposingly I have a car to sell and I will be selling it for cash or for some other consideration. It is not freely, no. Free may I will not be distributing. It is not a charity going on. So in the case of transfer of shares, adequate consideration is supposed to be present, either in cash or in kind or whatever. But in the case of transmission, no consideration is paid. It is just because it is written in the will. That is why the person is going to get those shares. Next point is execution of a valid transfer deed. It is very much required in the transfer of shares, this transfer deed, and no such deed is required when we come to the transmission of shares. Next point is the liability. Now, supposingly, I am selling those shares. The moment I sell them, the liability regarding those shares I have no more liability as regards to those shares. If there is some unpaid amount on them and I have sold them, now the unpaid amount I am not going to pay. The person who has purchased from me, it is his liability to pay the unpaid amount of the shares. So the liability of the transferor, me in this case, ceases on the completion of transfer. Once I have transferred, I don't have any liability on those respected shares. But in case of transmission, original liability of the shares continues to exist. Supposingly, I have got some shares through a will, and there is unpaid amount on those shares which the deceased person had to pay. So now it's my responsibility. I have to pay the unpaid amount on the shares. So what I mean to say is that in the transmission of shares, the original liability will stay, and in the transfer, the original liability is no liability. The buyer, now he'll see the case himself. Next point is the stamp duty, which is very well payable on the market value of shares. In the case of transfer of shares, stamp duty is compulsory to be paid. But in transmission of shares, there's no need at all to pay any stamp duty. So here I come to the end of the article. I hope I have made the things very clear to you. In case you have any doubt, please feel free to ask me in the comment section. You want to give me a suggestion, more than welcome, write in the comment section. Kindly like and subscribe to my channel. Thank you for watching. Stay safe, stay blessed.